Okay, Ms. Duff, I know you announced 30 to 45 minutes. It may be quicker since I don't think Mr. House is going to appear, but I've got two other ones that are going to be really, really quick. So I'm going to take care of them first so that they can get started with their day, or whatever they
Right.
need. Miss Bernadine Miller.
Yes.
Okay, on your case, there's no service on your husband yet, which is, so there's really three steps to getting a divorce. The first step is you file a petition for divorce saying, Judge, I want a divorce. The second, and you did that step correctly. Everything's done perfectly there. The second step, though, is you have to have your husband served with papers that tell him he's been sued and he has 20 days essentially to file an answer to the lawsuit. Or if your husband will cooperate, he can just sign what's called a waiver of service. And he says, hey, I know I'm being sued. I don't need some officer coming and giving me papers telling me I'm being sued. From your pleadings, it looks like you're trying to have him served. You don't think he's going to cooperate. But the problem is that still hasn't been done. And so we as judges don't have any power to do anything until your husband's been served with that lawsuit. So I can tell if you know where he lives and you have an address for him, then you just have a piece of paper you can fill out at the district clerk's office and you give them his address, and there'll be an officer that will go out there and try to get him served with the papers. And then if that doesn't work, then there's some other steps, and I can't tell you exactly what to do because as a judge, I'm not allowed to give legal advice, but I can tell you, like Judge Heppard said to the other lady this morning, you can go to www.texaslawhelp. That's texaslawhelp, HELP.org. And they can kind of have some instructions on what to do when you're having trouble getting someone served with a lawsuit. And that may help you, give you some instructions on what you need to do to get him served. But unfortunately, I can't do anything today because we don't have him served yet. So that's the step to focus on. Because once he gets served, then the court gets the power to grant the divorce, and we can finish your case once that's done.
Okay, I do have one question. If you don't know where they are, how does that work?
So I would
Like,
go to
you have no idea.
Yeah, if you go to that texaslawhelp.org, that's going to help you there. And you can look for when you don't know the person's address, or they're what we call a transient person, where they're just all over the place, don't really have a fixed place that they live. It'll tell you a motion that you can file and then an order that you can file that we can sign as judges that say, well, rather than personally handing him the papers, we're going to do it by publishing it in a newspaper, publishing it at the courthouse. There's some ways that you can get it done, but you just need to go to that website, and I'm hoping that helps you. If not, you might call a lawyer and just ask them to give you some instructions on what steps you need to take to get there. Okay.
Okay.
All right. Thank you, ma'am. Sorry.
Okay. Thank you. No problem. Thank you.
Okay. And then on, I lost Ms. Coleman. All right, Mr. Lewis and Ms. Coleman. How are y'all doing?
I'm fine, yourself?
I'm doing well, thank you. So I saw that you filed your pleadings, and that's good. That's similar to what I was telling the lady just before y'all. That's the first step in getting where you want to go. But before the court has any power to do anything, you need to have the other players served, meaning the and I forget if it's an aunt or who has the children, but
Yes, it is.
yeah, you need to get that person served with your lawsuit. So you filed your lawsuit, but as a judge, we don't have any power until that gets served, which is, someone goes out and hands those papers.
Mr. Bill.
Yes, sir.
Mr. Bill, I served the first time that like I sent, the lawyer gave me 3 papers to send to the child support, her, and to your courts. I sent it to him. She ain't responding. I just don't, I just found out, I found her address, and because I took a picture of a license plate. That's the only way I found out where she stayed. I don't even know where she stayed.
Well, and you
I
can't,
sent the paperwork over.
yeah, it has to be a licensed person that hands these papers to them. It's because it's an official step. And until that's done, because then the person that serves the papers, they know that they have to file something with the court, and they have to file an affidavit that says, Judge, we got these papers on this date at this time, and we served them to this lady on this date at this time at this address. And once that gets filed, then that gives me the power to do something on your case. And then if they don't appear, if they don't appear after they get officially served, then we can hear your case without them even being present. It's called a default. But they have to be officially served. They can't be served through you. It's got to, what you need to do is go to the district clerk's office and tell them you need to get service of your lawsuit. And then they're going to give you a piece of paper to fill out. And then, because they're the ones that get it served, you just, you need to request it.
Oh,
You can't serve it.
so Mr. Bell. So when I got the mail certified and all that, what was that for?
I don't know, but that you can't serve stuff yourself. So I don't know who told you to do that. But
My lawyer had said my lawyer been real sick. He's an older guy. He's been really sick. He couldn't even show up today because he getting his wounds fixed this morning. So, like I said, I had the paperwork. I had to send the paperwork to the child support, and I sent the paperwork to her through legal mail.
He certified.
He certified the mail.
He went and certified it and mailed it, but that's how we got it. So
Yeah,
I'm saying,
unfortunately, that doesn't work. You might check with your lawyer and just tell him that the judge is saying that you need to get service of your lawsuit, and he may be, when he's feeling better, he can maybe give you some instructions on how to do that. The other option is you can go to this website that's kind of there to help people that don't have lawyers. It's called www.texaslaw.help.org. And you can go on there and just search how to serve someone, and that'll tell you kind of the steps to do it as well. But you're going to want to go to the Fort Bend District Clerk's office and tell them you need your lawsuit served, and then they'll give you a piece of paper to fill out, which will get it done the way that we need to get it done. Because unfortunately, the certified mail is not gonna give me the power to do anything.
Okay, so Mr. Bell, I can go down there this morning.
Yes, sir.
And get the paperwork. That's what I'm gonna do then.
Eugene Hyman, right? Circle Eugene Hyman, the Fort Bend.
Yes,
What we did.
And y'all want to get that done right away, because once that's done, then as a judge, we have the power to do something. But right now, Judge Hepper and I can't do anything for you. Okay.
Okay, we're going down there this morning, Mr. Bell.
Okay.
Judge,
Y'all have a good day.
All right, man.
I just wanted to ask you.
Hold up. Go ahead.
I just wanted to ask you, did you remember the case?
I remember the case. We have like 3,000 cases. So I don't remember
I
all the
understand.
details, but I do remember the case. And
Promise me.
yeah, so just get that stuff certain. Like I
Okay.
remembered it was an aunt, but sometimes
Yeah.
it's when I hear voices, it triggers kind of facts on cases sometimes.
I
But
understand.
yes, so y'all just get that served so that we can take care of you.
Okay,
Thank you,
sir.
Judge Bell.
Thank you both.
Have a good one.
You too.
You ready?
Yeah, I'm ready.
All right, Miss Duff and Mr. Gregory, y'all are on the motion to compel. Oh,
Yes,
when I was looking at this yesterday, there was two cases that I looked at, and both of them were fairly old. This case I show is like 865 days old. So we do need to get a trial date set. I know that if you've got a motion to compel, there's documents you need to get ready for trial. So I get it. But I do we need to have the motion to compel. And then I also want to give y'all a trial date so we have an end in sight on the case.
Your Honor, just to point out, there's been a couple other issues that have come up, specifically in terms of support for the child who's the subject of this suit. We are in the process of amending our pleadings to address that. One of the things, in particular, two issues are Mr. House has two children from a previous relationship, and they've aged out now. And then also the child who's the subject of this suit is special needs. So we were going to move through that process as well now to try to save Ms. Valdez some funds.
Sure. So, and I'm going to give you plenty of time to amend pleadings, do what you need to do, but I just want to so we're talking maybe 60 days out or so. I just don't want y'all to end up on a DWAP docket, which we're doing every other month or so. We're doing about 25 cases, and we unfortunately have some that are older than 865 days. but a lot of that came from when January hit, the 268th and the 434th, their family cases came to the family courts now. And
Yes,
so
sir.
some of those cases, they just didn't do DWOPs in those courts. We have stuff that's 7 years old that we're trying to get rid of because these people have been under litigation for years. But I do know 865 days, you're going to be getting a DWOP notice, and then it'll be set a lot quicker than what I can do for you today. So I just want to get that taken care of after we finish the motion to compel.
Yes,
But,
Your
do
Honor.
we have notice to Mr. House? We got that lined up because I'm about to get on the record and we'll get started.
Yes, Your Honor. Did you want me to tell you
Anyone-
when that was right now, or hold on until we're on? the
No,
record?
just I just want you to get it ready. So, because we're going to get on the record and that'll be the first thing we address. How about those Astros? Pretty good. Huh?
Yes.
Holding my
I was,
breath.
I got in my car to drive home, and since y'all are my last case, we can talk a little bit, right? I'm not rushing to get
Exactly.
next people, but I got in my car to drive home, and it was like 5:30, and so I was like, oh, I need to turn on the game and see. They're probably close to finishing, and Altuve had come up, and they were just booing him like crazy. And I was like, wow, that's pretty loud. And then he hit a 3-run home run, I think, on the first pitch. It's like, well, that's how you silence a crowd, right?
It was already a little silent before then. I think we're going on Saturday.
Are y'all
to the
going
game.
Saturday?
Yeah.
It should be a fun series with Boston.
Yes.
The court's on the record in cause number 17 DCB 238468 in the matter of the marriage of Robert House and Beatrice Valdez. Counsel, if you would, please each identify yourselves and the party that you represent for the record.
Elizabeth Duff for Beatrice Valdez.
William J. Gregory for B. Valdez as well.
And what do we have set this morning?
This morning, Your Honor, we're set for a motion to compel. Just to refresh the court's memory, we were here about this time last year on a previous motion to compel. And Mr. House to date has still failed to timely respond or produce requested documents or timely eject. So we've had to bring this matter forward again to the court's attention.
And do we have notice of this hearing to Mr. House, Mr. Gregory?
Yes, Your Honor. Service of the service of the motion was e-served to his email on, I believe it was October 5th. And then we also emailed, we also sent the motion to compel to him in a letter via email and e-service, as well as certified mail return receipt requested on October 7th. So he's had ample notice of this hearing, Judge.
Okay, and for the record, the notice of hearing sets the motion to compel for 9 a.m. It is now 9:35 a.m. and Mr. House has not appeared. The notice told him to appear via Zoom and gave the meeting ID and the passcode, and Mr. House has not appeared this morning. So we're going to go ahead and go forward with the motion to compel. And Mr. Gregory, you may proceed.
Okay. And Your Honor, just to refresh the court's recollection, when we were here last year, there was an issue with his email address. We corrected that issue. We resent him at that time request for disclosures, first set of interrogatories and requests for production. He assured Your Honor at that time that he would adequately respond to discovery, and to date, the only thing we have received from him is his 2018 tax return and a letter from his employer regarding his salary. However, we have not received any pay stubs or any recent tax returns or anything like that. And the only thing that we've received, and this is attached to as Exhibit C to our motion, was an email from him saying essentially he didn't have to produce anything except his 2018 return and his this letter from his employer, which I don't believe actually set out what his current salary was. It was just the salaries are going to be reduced. So it doesn't give us what we need to be able to adequately prosecute Mrs. Valdez's case. And that's why we're asking the court to compel Mr. House to adequately respond. And I can go ahead and Exhibit A of our motion is our first set of interrogatories. Exhibit B of the motion is the request for production. Exhibit C is Mr. House's response. Exhibit D is the request for disclosures. And again, Exhibit E is a letter that we sent him in January of this year regarding his failure to adequately respond to the discovery and pointing out the deficiencies to try to help him along. And again, we have not received anything. So that's the reason we're back here, Judge.
Okay. Well, the motion to compel is granted, and all of these answers and documents need to be produced. I'm going to give Mr. House a date certain to do that by.
And Your Honor, if you're,
It
I'm
looks
sorry to
like,
interrupt, Judge, go ahead.
well, I'm just thinking about how this case gets to trial if you don't get these documents, because as you all know, anything he doesn't produce is not going to be admitted into evidence. But it looks like you do have his employer's information. So at
Yes, sir.
least y'all have the ability to subpoena his pay records, which would give us an indication of what he's making. So that we can at least get child support.
The one thing I would caution the court there, Your Honor, that was from last year. And I know he works in oil and gas and there's been a lot of turnover. So his employer may have changed, but we will try to ascertain that and go to the source as opposed to trying to work through him. But I understand what you're saying.
And that's the thing, we just don't know. And if he's not cooperating and getting you the records and you need his pay information, then there's only a couple of ways to get that done. And I will, when I set the trial date, keep that in mind. But assuming this gentleman doesn't comply, which hopefully he does, then you may have to do a little additional work to get the information that you need. But and I'll give you time to do that. So the motion to compel is granted. He needs to answer all the requests for production fully. He needs to answer all the interrogatories, and he needs to answer all the disclosures.
And Your Honor, I do have I'm ready to testify as to attorney's fees as well from last year when you're ready.
Sure, I'm ready to do that now. If you would, please raise your right hand to be sworn. You solemnly swear or affirm the testimony you're going to give in this cause will be the truth, the whole truth, and nothing but the truth. So help you God.
Yes, Your Honor.
You may proceed.
Your Honor, since, and just to, again, point out to the court, this is the second time we've been down here. We were willing to move aside from the fees last year, but because he hasn't responded, I've included those in our calculation to date. To date, Ms. Duff has spent, including this morning, has spent approximately 1.5 hours on this case. Our legal assistant, Jean Davis, has spent approximately 7.8 hours working on this motion to compel. And I've spent approximately 1.8 hours working on this motion to compel, including today's hearing, Judge. The total fee, Ms. Duff has been licensed since the 90s in Texas to practice law. She primarily focuses on family law. I'm her associate. I'm not trying to age her here. And I've been licensed since 2017. Ms. Davis has been working with Ms. Duff as a paralegal for many years and is qualified, and her work has been supervised on this case. She's done the lion's share of the work to keep our client's costs down in this case. Ms. Duff bills out at $350 an hour. I bill out at $175 an hour, and Ms. Davis bills out at $100 an hour. The numbers I gave you, those amount of time totals up to $1,532.50 for this motion to compel. And we're asking the court to sanction Mr. House as requested in our motion and require him to pay attorney's fees for the cost of bringing this motion to the court.
All right, thank you. The request for attorney's fees is granted. The court is going to assess $1,532.50 against Mr. House. That will need to be paid by, we'll do November the 5th is the deadline for that to be paid. The responses to discovery, I think, I want to make sure those are due after we enter this order, because I don't think we've got a proposed order yet on it. So I'm going to set y'all for entry. A week from Friday would be October 22nd. Does that work for an entry date? And you can always get it in before then.
I believe it does, Your Honor.
Okay. I'm going to set entry then for October 22nd at 9 a.m. But if you can get me the order before then, nobody needs to appear on the 22nd and I'll sign it. So the answers to discovery are going to be due by Mr. House on or before October the 29th at 5 p.m. And then again, the sanction for attorney's fees is $1,532.50. And that needs to be paid by Mr. House to Ms. Duff's office by November the 5th, 2021. And we'll make that by noon on that day. Anything further that we need to address on the record from Mr. Gregory or Ms. Duff?
Not on the motion to compel, Your Honor.
All right, let's go ahead and get a trial date set. So my thought is, if in the event you have to subpoena documents, you won't know that until the 29th. And that's, so let's say early November. So probably what I can do is give you a trial date in late January or early February, just to make sure you have enough time to do whatever you need to do. So let's look at our calendars and see what we have maybe the first week in February. That would be the week of the 7th. Looks like I can do pretty much any day that week right now.
I think we're good. We're good that week. Bill, excuse me, Your Honor. I bruised some ribs this weekend, so I'm
Oh, sorry to hear that.
a little gimpy right now. Bill, what's your wedding date?
Believe it's the 21st of January.
Okay.
So would that be enough time if we did the week of February 7th? Or do we need to?
If we could push it out, I'm looking at our calendar here. I believe so.
I can do February 15th or 16th.
Let's do that, Your Honor.
You want to do the 16th? Do you think it's a one-day trial?
I think it's one day. It's probably even a half day, even if he shows up.
Okay.
Your Honor, I do want to caution the court too. This matter originally began with an enforcement action filed by Mr. House, and believe that is still pending. So just in terms of estimating the amount of time for this, if he does show up, then that would have to be addressed as well. But
Well, nobody, I mean, if it's a motion for enforcement, he'd have to have personal service of the new date on her. And so we'll address that if it's done properly. We'll address that when it comes up. So we'll set it for February 16th, 2022 at 9 a.m. for final trial. And that completes the ruling of this court. We're going off the record. All right, anything further that y'all need to address?
I don't believe so, Your Honor.
no,
All
Judge.
right, thank you. Thank you, Ms.
Thank you very
Valdez. Have a
much.
good day.
Thank you, Your Honor.
You're welcome.
Thank you too.
May we be excused now?
You may.